Hello and welcome to CTV. I'm Amelia Nakitimbo, and this is the month of the woman here in CTV, and we're bringing you special programming in the lead up to International Women's Day, where we discuss issues that affect girls and women in our society. And as we've been telling you all week, we are bringing you specialists and experts who are working actively in issues that affect young women and girls in our community. And today, we're talking about women and inheritance, which is a very key issue that is happening in our communities right now. Many times we see that women are marginalized when it comes to inheritance. There's even one person who wrote a book and was telling her story where she said it's a pity she's a girl because with all her brains and her experience, her father felt like it would have been better if it was a boy, because boys are believed to be better caretakers of property and women are seen as not belonging to the family. So with me to discuss this today is Dorothy Amuron. She's the Strategic Litigation Manager at CEHURD. Dorothy, welcome to CTV.
Thank you,
and thank you for agreeing to talk to us.
A pleasure.
I know that you have a wealth of experience in the civil society, and you've done different things in different capacities, but today you'll be sharing with us the journey of how the Women and Succession Bill or Act has evolved over time, because I know you also have, we're going to tap into your knowledge in the legal community, but also we want to get to know, because maybe some of our viewers are seeing you for the very first time and they do not know the journey that you have moved. And as we've been doing with our guests all week, we start by asking, you know, many people have passion for issues that affect women and young girls, but you have turned that into a career. How did that happen? What sparked you?
Thank you so much, first of all, CTV, for actually honoring and treasuring women. Very few spaces like this actually give that special accord to women. So I'm really honored and really humbled that you're giving us spaces to voice out our journeys and rightly share where we've come, how far we've come, and what we project the future looking like for women's rights, and specifically within our context, Uganda. So you've already introduced my name, but
yes,
for the sake of the reintroduction, I am Dorothy Amuron, and I am the Strategic Litigation Manager of Center for Health, Human Rights and Development. And my journey in human rights started way back from, I think I started appreciating human rights from university.
University.
Yes. FIDA Uganda, I know you've heard about FIDA Uganda, it's been vocal on women's rights.
Yes.
We came to school, law school, and it was trying to talk about mentoring women in career paths, where you want to go and all that stuff, and how do you become a member of FIDA and all. And you know, then you're a student, you're just in that space and you're like listening in.
And you're trying to figure out which way you should go.
Exactly. But for some reason, you know, I didn't really think through that, you know, yeah, maybe probably like 10 years down the road, I would actively be advocating for women's rights. But I think it's also background beyond the career. Most people look at career guidance and all, but most of us are triggered sometimes by the environment that we grow or live in, for example. Personally, I was raised by a single mother, and I saw her struggles. I saw her maneuver through life to ensure that, you know, the five of us, we're five, had, you know, a livelihood, you know, access education.
The typical story of mothers and single mothers in our community. Exactly,
you can now relate. So I think for me, when I went on to law school, first of all, it was a choice for me to go to law school. Ideally, I didn't really think I would love law because I'm ordinarily a person that is more into hospitality and all. So I even told her, Mom, I think I want to do humanities, community psychology, or even drama. And she laughed. She said, girl, I didn't raise you this far to end up into such a profession. I want something, you know, fun for you, bigger, and you're going to do law. And of course, I didn't have the points to make it to government. It was private. So she told me, well, you can do whatever course you want as long as you're paying for it.
And
if it's not law.
Yeah. So that one conversation that you had, that Fida had with you at school, and I believe that's why it's also important for us to have this discussion, because I believe that maybe this one broadcast could also spark someone's interest into joining advocacy.
Yes.
And when it comes to succession and inheritance, you already mentioned that you're raised by a single mother. How was her journey in maybe owning property and working with family? What experience did you grow up with?
I think there was just one life-changing experience in 1992 when mom had tried to settle in and get, like, you know, have as a father figure. She'd gotten a partner that really liked her so much, and they were getting serious in terms of settling down. But as fate would have it, he was actually gunned around in Tinder.
Oh dear.
That was about 1992. So he had different wives or spouses too at that time, and when he passed on, I saw the family more interested in the property. Everyone kept asking, where is this, where is that? Amidst the morning, no one was bothered about how the children were going to cope after that or this.
And the shock of losing this would-be father figure.
Exactly. So I watched, and everybody kept saying, you know, whatever was in his name, we want it.
And how old were you at that time?
I was about 9 years, 9 clocking 10.
But
about
something
9.
was already forming in your mind, and you could tell.
Yes, so I remember one of my aunties telling my mom, you have to stay strong and firm for these children.
Yeah.
Whatever properties are there are for these children. But the kind of mom my mom was, by that time of that incident, she was already empowered. She was, you know, this lady that hustles. She was an accountant by profession, already working, and pretty much by the time she was getting into this serious relationship, she was staying in her own home.
Yeah.
And whatever properties she was getting, they were personally in her right title. So
was there a will by the time this gentleman passed, so that maybe there's something that is allotted to her? And did her property also get into the mix at some point?
Unfortunately, he died intestate. He did not have a will. And so definitely the journey wasn't going to be smooth, and it never was. So nothing really prepared us in terms of what the future looked like for the younger siblings that he had with my mother. So basically the whole burden was back to her as a single mother.
And later on in the program, we'll be joined by a very seasoned journalist, Kassim Kayira, who will also be sharing with us his experience that spans different communities, because we're talking about the Ugandan context, but I know that he also has experience and has worked, reported across the region, in Rwanda, in Kenya, in Congo, and he'll also be bringing out some of those aspects and the personal experience that he has shared as we're talking about reforms and laws and policies. Earlier on, we're having a conversation where you told me that, well, it's also fact that the journey for the succession bill that includes women and is favorable for women and children and young girls has started from way back, in colonial time, which a lot of people may not even think of.
Yes. So the Succession Act has had a journey, like you rightly state. Now, we've been operating under the British laws. And I think the first succession ordinance started in, the journey started in 1907 or 6, thereabouts.
Yeah.
And most of these laws, we typically inherited them.
I think it was 1906.
1906. Most of these British laws were really typically inherited.
Yeah.
And what this means is that the British just, you know, like imposed on us values or laws that were not resonating with our cultural setup. Yeah. We very well know that, you know, the British look at, you know, one partner, one wife, one husband, like these church marriages that we celebrate.
Which is not the case in our society, because we have very polygamous families with multiple wives, and usually there's no, some of the women just stay in cohabiting. There's no official marriage, which complicates succession.
Exactly. So we had to look at it from that context of how do you protect the women who are actually in the polygamous families. So that's how the journey started. I think we had I don't know if we had about the Kalema Commission, which was questioning customary laws and what happens to women who are customarily married, how are they protected? Now, when it comes to succession and inheritance, oftentimes, like you earlier said, the boy child is favored, and even our laws did not really help. As we speak right now, thankfully, the government of Uganda has really tried to be progressive in nature. You can see the spirit in the 1995 Constitution on equal rights between men and women under, I think, Article 31 of the Constitution. And then Article 32 talks about affirmative action for women. And then you have another article, I think 33, that is talking about women's rights. So you can see that spirit. But this journey started back in, I think, 1972. Then it spans across to the 1976, where we had the commissions, the Rhoda Kalema Commission, which was, questioning how women were protected, especially in instances of inheritance. We had the Bushenyi. There was also another Bushenyi inheritance research that was conducted to find out how the actual realization of inheritance was working out, even for women or the girl child. Eventually, we see the Uganda Law Reform Commission also come in, I think in 1994, to interrogate further how women can be protected under the law. So that's how the journey has been. And then we see now in 2018, the actual discussions on the amendment of the bill catching fire, where we want to use gender-sensitive language or terminologies and to consider children illegitimate or legitimate. These laws were really that biased and forgetting our setup. And that's what the amendment
talked about. So you keep it right there. We're going for a very short break. And when we return, we'll be looking at the clauses that caused a dispute. Recently, the succession bill was amended, and we'll be delving deeper into the different clauses that were amended, especially to make them favor women and girls and children. She mentioned something on illegitimate children. This is CTV Month of the Woman. We're going for a very short break. Don't blink.
We entertain you. Ngawe tukuwate. Amanya shame manja omobwa President Birabiri Mokaga akabone record. Nanga wento naliya nafuka ikankomya aliya one but tikutemo olwaleero.
Ani tubasuubiza ntugenda kubanga tuli mu bitundu ebyenjawulo.
Ani yayambadde obulungi. Kakoye ki akazze ku mulembe. Ne gown ya black erina tiara ya black.
Tiara.
English of my kind. Tiara.
I feel the beat.
You feel the beat?
Yeah.
Olokwa bakutwe together about feeling the beat. Show badiyita situations ko ground. This is a professional that you yako.
Vera Coco CTV totally.
Don't blink.
Now showing on CTV. Don't blink. As we embark on a journey to realize our full potential, we all need expanded minds and limitless possibilities. We need to be accurately informed. CTV is your growth partner. With reliable, in-depth news, we tell the story from all perspectives. We bring you the story in real time. Catch our comprehensive daily bulletins in Juba Ekolodie at 7 p.m. and PM edition at 9 p.m. CTV, don't blink.
Welcome back, and if you've just joined us, you're watching CTV Month of the Woman. That is special programming that we are bringing to you here on CTV in the lead up to International Women's Day. We are bringing you specialists and experts who have knowledge and a wealth of experience on issues that affect young girls and women. And the reason why we have International Women's Day is always to shed a light on issues that bring about the inequality that women face in our society. And today we are talking about women and inheritance, which is an issue that is very pertinent to the women in our communities and the children in our communities, because many times when it comes to sharing property, women are put on the side because they are not considered maybe good custodians of property, which is quite wrong. And today we have a litigation officer, one with a legal background and who's been working in advocacy for a long time in different spheres, and she is already sharing with us the information that she has had. But also on set, as we had promised you, we have Mr. Kassim Kayira, who is a journalist with a wealth of experience across the region. Welcome to the set, Kassim.
Very much.
So earlier, the reason why we are also having you here is tapping into that experience. I know that both on your personal side and both in your career, you've come across, you've traveled across the region, and you've observed how succession affects women and girls. I'm curious to know from your travels, what experience have you observed? What have you observed on how maybe the different communities in Rwanda, the different communities in Kenya, how do we compare as Uganda to the other communities?
Uganda actually does compare quite favorably. However, each country, I mean, the deeper you go sometimes, the more you realize there is more than what you just see on the surface of it. Let me give you an example. In Rwanda, for example, the law has been existing for a long time. And it's actually very, very, it's strongly in law. If you're to get married, you have to go to the commune, so it's the registry. So even if you get married from the mosque or from the church, a woman will still insist to be taken to the commune. And by going to the commune, they get into your ID, and once they are there, that protects their rights.
If I'm hearing you right, is that different from, because usually here in Uganda, you'll meet someone, you like them, and somehow you move in, and you forget about that legalization part.
Yes.
Is that the difference that happens
That's
in
the
Uganda?
difference. In Rwanda, for example, actually for a wife to be officially recognized, they have to go to the commune. The religious one will officialize your own existence. So it's the church, it's the mosque. But then once the person goes to the commune, they become part of your national ID. They are there as umufasha wawe. That is your spouse. By entitling them to being your spouse, then that gives them the right to access your inheritance in the case or in the event that you pass on. The only problem with that is that then in Rwanda, the law sets out that a person is supposed to be married only to one woman. With the population of probably about 10% or 15% of the Rwandan population being Muslim, what do you do with the religion that allows for the marriage of 4? You cannot have the 4 wives all in that. You go to the United Kingdom, and another very interesting scenario is the same. You go to the registry, or even if you did a church wedding, as long as this is the recognized wife, it is one wife. But then you'll have again Muslims again, because I keep bringing that because that goes into the picture. How do you maintain people who have fled, for example, from Afghanistan, from Somalia, where there's been war? You flee into the country, you are granted asylum, you become a refugee. Yeah. That assumes or allows you to have particular rights. Yeah. But then I came with my 4 wives. What happens to the 3 wives if only one is going to be recognized? What has happened is that in that state is that the law allows now for a person to have a spouse despite having a wife. So you can have like a girlfriend on the side. That's a funny thing. So a man ends up having 3 women who are girlfriends, and then you have the official wife. That entitles them, because there are times when you live with someone as if you're married. That's another. So it's cohabitation, but you're living together as if you are married.
And
as if
in
you're married,
Uganda, we make it worse, because the moment we see you with someone, we immediately start saying your wife, your husband, which gives a wrong illusion.
Yes.
Yes.
So when it comes to inheritance, I think that can be tricky. Uganda has made, because now we've managed in Uganda as well to navigate the two journeys. We have the secular journey, which is the court system and so on, yes. But the tradition is also strongly embedded in what we have. So as a result, for some reason, while the law will be there, it's only in cases of conflicts. When conflicts arise, then the courts now will take precedent, because then you go to court. Other than that, the traditional system is set up in such a way that a person will die, we will know that this is the official wife, but this is the other wife, and then they'll have a right as long as the children, they come and say, the nose looks like the father's, so we acknowledge. The moment there's that acknowledgement, then it comes to that. In the context of, say, Islam, Islam actually, if you see, it has, if there is any area that it has gone to in so much depth, it is the dealing with the estate of the deceased person. Yeah. It has already been distributed. There is nothing that we only come to put into practice what has been laid down. So much detail has gone into it that if it was followed to the letter, we would not be having any issues of a person who has found themselves dispossessed, because every portion is there. For the wife, their right is there. How much goes to the wife in case she has children, because that changes. If you don't have any children, the estate is much bigger. If you have children, it goes down because the children have to share. If there are close relatives, because you never know who has contributed what to the entire process, someone building up the estate.
So in comparison of communities, say between Rwanda and Uganda or other neighboring countries like Congo, are the fights for inheritance or taking away property from the woman as ferocious as we see here?
No, they are ferocious all over. It just depends on the circumstances leading up to. Yeah. Dorothy was talking about the issue of, say, having a will. When a person dies intestate, that leaves very serious problems. And the will writing, whenever people talk about wills, it's like if you write a will, you have admitted that you're going to die.
Yeah,
as if you won't die.
You know?
There's just that, are you going to die? Why are you writing a will? Yeah. But the lack of wills now has really led to very, very serious problems, and that cuts across the board. So people's conscience and awakening towards the issue of having a will. And people to know that actually a will is not just the written word, because now with technology, you can actually have a recorded voice if it can be verified. If it can be verified and secured with a lawyer, for example, it might be that you cannot write. And someone writing, sometimes they might write what you are not exactly referring to. But if it can be recorded and put in recording, that recording can actually, especially if shared with more than one person, it might be. That's the test case, of course, that it needs to go to the courts and see if we can allow that.
It would be interesting to do that, you say?
It would be, because I mean there should be alternative means of ensuring that everybody receives justice in whatever form. Because sometimes if you're not flexible and the law is not serving the people, society is not static, for example, and circumstances vary. So probably admitting only what is written is more protective. Even the proposed Succession Act actually suggests that every page should be signed on to ensure that there are no variations. Actually, that's what the new succession law proposes, to ensure that issues to do with forgery of wills and all is dealt away with. But I think given the circumstances, like he rightly says, it should be expounded on, the circumstances should be expounded on to even probably consider safe voice recordings, as long as they can be authenticated, like they can be proved to be authentic.
Yeah,
it would be good.
You mentioned the amendment of the succession bill. What are some of the issues that you think are very, very important, the amendments that have been made in the Succession Act?
Okay, one, of course, the Succession Act is interesting, and the law of inheritance is interesting. Succession is basically what happens to that estate of this deceased person after the affairs. And then inheritance is the heir, who is the right heir or heiress to this kind of property and what is recognized, who is who. Now, what is interesting in the proposed amendments is actually the redefinition and equality principles being applied throughout. You can clearly see that the language, the construction of the amendment clearly brings in the neutral language of a child, like the girl and the boy
are recognized. As opposed to saying man, as being an heir or boy.
As long as you adopted in the right way and in the laws that are recognized within Uganda, you're a child, okay, of this deceased person, female or male. So we see that even the issue of hair is going back to being redefined in terms of the languaging, he or she. You know that most times when we're constructing these documents, we kind of tend to be blind to some of the framing of these languages, but we see that
it comes with the bias of the person who's creating the bill.
I think the shifts have been successful because Uganda honestly has made great strides when it comes to recognizing equality, gender equality in our country. We have the National Equality Policy that guides on these issues of equality. We've seen the spirit of the Constitution in the different articles really try to breathe life into recognizing that women and men, for example, have the right to form a family, have the right to own property equally. So you see that we've made that spirit, and that is the same spirit that you recognize in the case that was filed by
It was by Law and Law Advocacy for Women in Uganda.
exactly in
Yeah.
2005. It's a constitutional petition of 2005, petition 13. Now, the essence of this case is it says that the provisions in the Succession Act are unconstitutional because they are discriminatory in nature. And over the years, there are different cases and challenges that have come through, and they leave a lacuna or a gap in the Succession Act. Now, what this law actually brings to light is the fact that how women were treated. And when we say women, again, we have to differentiate, because when we're looking at the Succession Act, there's a proper definition of who a spouse is. And this is a person that is recognized by law.
As a partner.
As a partner, yes. Whether you celebrate this marriage in church, customarily, civil, as long as it's recognized by law, you pass for a spouse. Some of the changes are interesting. We're advocating for an increase in what kind of share goes to the immediate.
Yeah. So now,
Yes.
just bringing that up, because
Spouse.
he brought in a very interesting angle of, say, the Muslim community where you're allowed more than one wife. And if the law maybe recognizes one spouse and you have the other children. I know one of the things that the amendment fought to bring to light was the use of illegitimate children. But now the amendment says children who are born out of wedlock. And I'm curious to know if, for example, you met someone and you had these children before you were wed, and then you get married. Does that also affect those children? Does the amendment now leave out those children because they were born out of wedlock?
No, it does not leave out these children. The law is now recognizing children as children. It does not put the classifications of illegitimate or gotten before marriage or after, as long as there's proof that actually you're rightfully in that line of this person, or you've been adopted in accordance with the law, you qualify to be a child in the definition of the law. And I think what the Succession Act has done is, initially they were recognizing children of age as 21, but now
Yes.
children of age at 18 to be consistent. Like, the inconsistencies are trying to be polished.
With the constitution.
Yes, but I think what is critical for you to note is there's no differentiation now between illegitimate, legitimate, or gotten before marriage. No,
Yeah.
children are recognized as children.
I'm curious to find out from Dorothy, Martha, regarding the children that are born out of wedlock,
Yes.
but then only brought in at the time of death. Or quite often you see we are in the wake, people are crying here, there are some people who cry more than others.
Yes.
And in the process you come to realize these are women who have turned up with children from a relationship that was not official. How does this new reform actually
Amendment,
deal
yes.
with that? How does it address that? Because they are illegitimate, but also the fact that the father never got to see them, and they've just been brought at the time of death, in which case the recognition of these children by the father is not authenticated. Does the law deal with that, the reform?
Interesting twist. Fate can have it that way things happen. I think one, and just kind of getting off this, is there are men who are strategic.
Yeah.
They will plan. Now, this is not the instance here. Those that will include the children in the will and in the distribution of his estate, the properties and all, they will appear, whether known to the spouse or not. Now, that is quite a settled issue. Now, where this happens, the instances have actually happened where they actually bring these children. Now,
In fact, there was a recent case, I think last month, of a man who passed on, but he was quite wealthy. It was on the news. He had a wife, a known wife at home, but then I think in his career he met another person in office, and he had built homes for both of them. So this woman, not knowing about the other life, they both thought they were the women.
legit.
Yes, and like we mentioned earlier, especially when someone just moves in with you, they build your house, and they are taking care of the children. You just assume I'm the wife. I mean,
Okay.
so, and then at the time of his death, now both women show up.
Those instances are real. They've happened. We're not even putting hypothetical situations.
Yeah.
Now, I think there's also a law that guides on that in terms of, I think under the Children's Act, and even the Constitution in terms of the right to belong to a family, for example, parenthood, custody issues and all, but also specifically in these circumstances, I think that what would be important to actually find out is is this child actually this person's child?
Yeah.
Because then, of course, you cannot just embrace and say, oh, yeah, he's gone, the nose looks like this and all. There has to be proof, and that's why over the years, DNA tests have been carried, because some of these issues go to the administrator's office of the estates, and the disputes arise, or we're not even sure if this child is this person's and all. So most times, I think the DNA test would really help resolve these issues, and it's sad that they actually exhume. In some instances, actually, they've exhumed bodies of people to ensure that these tests are conducted, or it strains the family actually, because now they either say, let's look for the brother, and you have to be sure probably this, you know, the blood and all. You're now assuming that actually the line is not tampered with for you to prove, but in most cases it would be advisable to actually go that extra mile and have this DNA conducted, or even sometimes people inquire, like, you know, who used to move with a man? Maybe there was this collaborative evidence, you know, like how you're trying to gather those facts that relate to this person's lifestyle before. Because not everybody probably would even have the privilege to have a DNA test conducted. So they go into the circumstantial facts around the whole mystery of these children that have just popped up. It's quite a bit complex, to be honest.
I think the dilemma, Martha, is there are even instances where there are children who have been brought, and even the deceased didn't even know them. You know, there are a woman who will go have a child,
at that
and they
point
just
we
keep
cannot
it.
tell that the deceased knew or did not know, because they cannot
so
speak.
in such a case now, because now this one has dealt with the ones that we know, there was that quiet family, you know, continuing with life. But then there are these people who simply appear. We are seriously in the work, and someone says, "Omwana we wuno." And you know, they start now, the aunties will come up and start describing Matwechi, the forehead really looks.
Yes. And I think also it depends on the family.
It
Depends on the family. Because you know, when people are going through grief and all, sometimes they don't digest, or they are desperate. There are people probably, like they say, this is a child when the man has never had a child before. And it's a welcome move, you see. And then also, I think within our context, we people that welcome, we embrace easily and all. We do not really go to those details, but where there's property, to be honest, the issues change. Obuntu bulamu goes away.
Yes, and it's a very curious case indeed, because that always happens usually at the time of grief. That means I think as a community, it has just hit me that we never grieve in peace, because property and succession always comes in. But there's a different dimension that I want to take us to. In your line of work, do you feel that the media is doing enough to highlight these issues, or maybe how we are covering them, so that maybe community is sensitized enough, and we also help to champion a smooth transition from, you know, the owner of property to the heir or heiress?
Is that to me?
Both of you, you can take it up.
I thought Dorothy was taking it first. All right,
no, you could.
Okay. From a media perspective, I think this is one area, this is a new area for us. We've been covering inheritance and whatever's, but I don't think we have done it justice. And I think sometimes it's not really out of ill will, it is so much about ignorance about it.
Yeah.
So I think there will be
Is
need
it
now
ignorance
for
or lack
organizations.
of interest?
No, it's not even lack of it. There might be, well, it might be a combination of lack of interest, but more to do with ignorance. You find that a lot of times when you don't know how to report on particular issues, the sensitivities surrounding this, then the law, you know, how do you draw yourself between the law, but also the sensitivities, because there are community sensitivities surrounding, you know, particular issues. I know media houses which, you know, sort of jump onto succession stories that you've seen a few, you know.
Especially when there's drama instead of going
that's
into
the
the
drama
issues.
actually.
Yes.
You have a sheikh,
Sensational reporting.
a famous person who has died, and then the next thing is, you know, it's just and you just see endless stories of that. But you see the lack of knowledge of this, and sometimes there are vested interests in this. You find that one party like pays, unfortunately the media is bought to enhance or advance a particular line. Yes, and if the other side doesn't have the right, or is so angry having seen what has run and they fail to give their side of the story, you have a one-sided story. I think for the media now, that's one area that as the reform is coming in, we are also there's very serious need, even from a parliament level, if not at least from organizations like FIDA that do advocacy, at least at that level, to be able to come in and help the media understand. Because the more you appreciate that, then you'll know the language to use, you know the sensitivities, you know what sort of things to look for. Because quite often it's easy, and that's why it's a combination of both ignorance but also self-interest.
Or even lack of interest. In your time with FIDA, now with CEHURD, what has been your interaction with the media relating to such issues, and how do you feel, or where do you think we could do better?
Okay, he's rightly spoken on behalf of the media and kind of shared his experience, but I want to agree with him that most times people find it complicated to report on issues that they do not appreciate. And so I think there's a clear gap in terms of being intentional with civil society organizations, partnering with media associations, for example, to actually have media fellowships, for example, on different topics, where you come in and you say, right now there's an amendment that is going to be passed or that is being debated on the Succession Act. What is our role? How do we meaningfully or impactfully report, and not, you know, reporting in a sensational manner of, oh, gundi haji gundi alisaba bameka, you know, what next and all. Like, we need to shift the minds from sensational to impactful reporting, but from a point of you have the information about the law at the fingertips, but also you're balancing with what your cultural setup looks like, and also the religious beliefs. You're creating a narrative that is creating perception and mindset change. So I think having like academies or even humanities schools taking in the media to appreciate the concepts of human rights. We have the schools of law, schools of gender and women studies and all. Perhaps if they design certain curriculums that coexist with the media fraternity, they would be reporting better. Because when I was working in FIDA, for example, women's rights were reported when there was like disputes, like he says, it would come at the forefront. Or when there were issues to do with understanding the law on wills, they would come in to ask you from that perspective. But as and when the need arises, because sometimes if you want to popularize issues, you have to be consistent. You don't just hit it once and then you go back. You have to be consistent in your narrative, because in the end, if you identify injustices in an area, there's no way you can advocate successfully without having a marriage with the media. Because the media comes to amplify. You can conduct your research, you can discuss and deliberate, but if these narratives or if these discussions, for example, on the Succession Act amendment, do not make it to the media houses, both print, audio, vision, then you're not communicating, because for these laws to pass, you need the support of the public. Because the public is what influences the law. It's very difficult for us to start imposing laws, and that's why the implementation of laws becomes difficult. Our mindset as a country is in the right place in terms of gender equality and justice, in terms of preventing gender-based violence. We ratified to the international conventions, the CEDAW, non-discrimination clauses, advancing for the principles, but who is consuming this? We have to have the bottom-top approach. So I think partnering with the media would be very good. And when we say national, we cover national to districts. We're just not concentrating on the cream that we think, you know, can read and write. You have to communicate, because most of these issues or injustices actually happen right at the grassroots. At the grassroots.
I think someone was even proposing the translation of the Constitution,
Yes, are really strong in there. So I think for me, in the years, the topics have been covered as and when there's a dispute that has made it to the news, or the issues of amendments and laws and wills is not really out there for me from the media, and I think we can do more.
So that's a call to action on both ends for the organizations involved, for agencies like government, and for the media to take this up. Though I'm curious, what do you think causes that? Because like we rightly mentioned, these things, we live with them every day. Why do you think is there like a fear to report on that? Is there maybe a cultural bias to bringing up these issues? Because I understand that one of the reasons why the media might stay away from certain things, leave alone lack of interest or ignorance, like you mentioned, sometimes we fear to touch live wires, if I may call it. Do you think that's the case here?
Yes, I think there is a disconnect, and while I was sort of seem to blame the media for a lack of adequate interest in this, I think it's also for the organizations. That's why I said, like for Parliament, for example, when such bills are being passed, there has to be a concerted effort to try to make it palatable. Because the legalese actually is always a problem, reporting, the legal language. It becomes so contrived, so constricted that it becomes difficult for the layperson to sort of understand. So there has to be a way of palatizing it, making it palatable, making it digestible to the ordinary person. And that starts with the journalist, because the moment the media understands it, then it becomes easy now to pass it on down. But also now, it shouldn't be an event, it should be a process. And being a process means we should be, and that's what I think Dorothy was referring to as the consistency. It has to be something that is coming in. It's said into your ears so many times, and now it becomes, part of you. You just feel like you suddenly become conscious.
What
just
they call
like the
sirens
on the roads. Just
theory.
like the sirens on the roads. Initially, people would even want to resist, but now you hear a siren, you see an ambulance, you can give way very quickly. If it's a minister, maybe you might resist a little bit. But at least the consciousness is growing a little bit, and I think that's where we should be going. So there has to be the effort to remove that disconnect, and it's on both parties. Let the media interest itself, but also very importantly, let the source of the law now take interest in approaching the media. The media should be open to that.
We mentioned how one of the clauses that was changed to make it, bring it in line with the Constitution is on how old children can take over property, from 21 to 18. But I'm still concerned. I do not know. You can advise us on this. Where in instances where, for example, the person passes on and the children are maybe 5 years old, 6 years old, usually we see promises on burials and funerals where, relatives say we're going to take care of these people, and then somewhere along the way,
there's misappropriation of
the
property.
So how can the law help us maybe to make whoever is there accountable? Does the law provide for example, the officiating, and we say this is the person who is taking over property, or it is to whom it might concern?
Not necessarily to whom it may concern. So the circumstances again vary. If a person was fortunate enough to pass on when they've left a will, the law has a provision of executors who will make this dream of his or his wishes come alive. And these are very well known. They are stated in the will. And it's upon these executors that are appointed to actually fulfill the wishes of the deceased person in terms of conducting his business even after he's long gone. But then also we have instances where people have passed on intestate or without wills. And, families have sat down to agree and come up with memorandums or, agreements to say this is going to be the way forward. They've sat in, chika, like, the clan members have said we've appointed this heir. Of course, that has also been a contested issue because favor has mainly gone to the boy child. Yeah. But I think the spirit of the Succession Act now, as is the way they're proposing these amendments, a child is a child. Even now, married women can actually say, this was my father's property and I'm entitled to it, because before there was bias. But how are these children protected who are minors, say? Even within that age that is still a bit sensitive, you can have guardians, for example, who are put in place to actually run the business of this estate, or to ensure that there's no intermingling of the properties. These things will always happen, but the law is also clear that you're held accountable, and the offense is actually to intermingling with the property of the deceased person. So when the circumstances arise and where there are triggers to show that this person is not actually managing this estate as should be, a lawsuit can be instituted against you.
So how does the law help children who say, or women whose spouses pass on and they've not written a will, and the family is coming after them?
I think the Office of the Administrator General, even under the Succession Act, clearly states out how to handle and manage properties where somebody has passed on without a will. Because most times, of course, they look at who is the immediate spouse, for example. Because most times we believe that that spouse would have the best interests of
for the deceased.
For the deceased. Yeah. And if they have surviving children, for example, they distribute it according to that. There's a distribution guide in the Succession Act on how these properties can be managed to avoid any controversies or inconsistencies, because most people take it upon their hands or law. And these are probably those that are not fortunate enough to know that there's actually a law that is guiding us on management of this property.
So that means we have to do a lot of sensitization on both ends, so that people know where they can go to have help.
Yeah, exactly. Like the Office of the Administrator General, for example, there is a section specifically that looks at administration of estates of deceased persons where people can be guided on the right procedures to take.
I wonder how much has gone into looking at religions. Again, because from an Islamic perspective, like there was an effort to try to legalize Qadhi courts, the Muslim courts.
Yeah.
There was an effort to try to legalize them, in which case their rulings would be binding. I find that actually if you look from the review, the law reform on this, how much consultation went into religions, because you'll find that, for example, from an Islamic perspective, it lays out very clearly, like this entire process. If someone died without a will, what would happen? In case there are even wills that are written, actually is there a new guidance under this review in terms of how a will should be written? Because they're saying that someone has written a will, but the will itself, it contradicts itself. In a situation where a will contradicts itself, what do you do? Because from an Islamic perspective, in the Islamic Sharia, for example, if a will contradicts the law, then the will is put on the side and they have to follow the law. If, for example, a person came and said, I've left all my property to one child and you have 4 children, that can't be fair. So automatically, alarm bells are raised. So how do we deal with such situations where even a will, is there a deliberate effort, and that again goes to the organizations for advocacy to sort of tell people what should be included in the will. So as you are writing a will, what shouldn't miss at least, because there are those basics.
And we'll come back to that, because in the next segment we'll be talking about solutions on how you and I and the person watching can be actively involved in the succession and inheritance, so that it's fair to women and young girls and children in our community. So you're watching CTV Month of the Woman, a special programming that we are bringing to you in the lead up to International Women's Day, where we are discussing issues that affect young women, young children and women in our society and girls. And here we're talking about women and inheritance. We are going for a very short break. Do not blink.
Kwepena is back. Come have original Ugandan fun and play the African way at the biggest celebration of Indigenous African Games. Make your way to the Uganda Museum on Sunday, 6th March 2022 and play Kwepena as you relive old memories and have a good time with family and friends. We shall also play games like Duel, Sonko, Mweso, Blada, and many more as top-notch DJs and performers keep you entertained. Early bird tickets are available at 10K online and 15K at the door. For reservations, contact 0784 218 964 or 0752 208 608. Kwepena is presented by Cheza and powered by Campus B, Up About, Party Prep 256, KQ Hub Africa, and CTV. Kwepena, play the African way.
Since 1963, this shirt has united fans and players across the country. It is more than just an article of clothing. It is a sense of pride for us as we catch the kinetic action. In the heat of the competition, we stand with our champion. This shirt brings us together. CTV becomes the principal shirt partner for KCCA FC. We are committed to the game, to bridge the gap and bring you closer to the awesome team you love. KCCA FC, more than just a club. CTV, don't blink.
We entertain you. Ngawe tukuwata. Amanya shami manja, omobwat President Birabiri Mokaga, akabonero court.
Nanga wento naliya nafuka ikankomya aliya one but tikutemo olwaleero ani tubasuubiza ntugenda kubanga tuli mu bitundu ebyenjawulo ani yayambadde obulungi kakoye kyakazze ku mulembe
ne gown ya black erina tiara ya black
tiara
English of my kind tiara.
I feel the beat.
You feel the beat?
Yeah.
Olwokuba bakuta ekigero oba ofiiringa the beat.
show bagiyita situations ko ground. This is a buffet kyagala kyolyako.
Beerako ku CTV totemya.
Don't blink.
Now showing on CTV. Don't blink.
Welcome back from that short break. You're watching CTV Month of the Woman, which is special programming that we are bringing you in the lead up to International Women's Day. Here on CTV, we are passionate about issues to do with young girls, women and children in our community, because we know that when we solve that, we'll be achieving the international goals on gender equality in our society. And we know that an equal society is beneficial to all. And as we have promised, we are always bringing you specialists and experts, people with a wealth of knowledge and information on issues, well, that affect young women and girls. And today we are talking about women and inheritance in line with the succession bill. And we are also discussing the amendments to the act, rather, that were passed recently, that were, made recently. And before we went for the break, you had mentioned something very important on how to write a will. We know that one of the reasons why disputes on succession often happen is because the deceased, especially when it's the head of the household, has not left a will. Yeah, so I'm curious to know, is there a proper way of writing a will so that it's not invalid? Because you had hinted on that earlier, and I'm putting that to both of you.
Okay.
Especially to you, Dorothy, since you have that. Yes, because you have the legal background.
Okay, I think under the Succession Act, Cap 162, there are clear provisions under the law that guide on how to write a valid will. I think under Section 50, if I'm not mistaken. You could look it up. Yeah. But basically, they are those critical things that a valid will should have, for example. First of all, this for anyone can write a will as long as anyone of age and you own some property. Say now age per the Constitution is 18 years and above, and you're of sane mind, like you have no mental health issues or dementia, or your health is not compromised, because they say you have to be.
That's also another point that we have to look at, especially for people who are suffering with mental health challenges, which are now very common in our society. True. Yeah, so of age, that means any adult who is watching right now is advised to write their will.
If you have your car radio, your very beautiful dresses, you don't have to wait to own land or cars or different things. For as long as you have things that are of value to you, you can actually make a plan that in case God called me today, this is how I'd want, my belongings to be treated.
Are there different types of wills?
I think there's the standard one of which is recognized by the law, and most of them are, you have to state the kind of properties you own as is. If it's land, for example, you have to state
the dimensions,
the titles, for example, because I think the law really gives value to people who own, like have the titles. You're more recognized. Of course, there are different circumstances. You could name, the cars, the number plates, for example. As long as you have proof that these are your properties and you're giving them out, and you have a plan on who gets what, based on what. Now, also, this will, when you're making it, has to be before a witness who has actually probably seen you or guided you. Like,
just
most
one
people
witness?
Go to lawyers.
Does it have to be one witness, or they can be multiple, or they should be
two
multiple?
Or three doesn't really hurt, and they should also sign onto this. Otherwise, if you write and sign off and it's only one witness, most times it becomes questionable before the law, and it can easily be probably messed up with or distorted. So you have to have also, like for executors, 2 probably or 3. Some of them could be within your family, they could be your close friends or your godmothers, someone that you trust that will not mess up your estate, but will act in the best interest of the family or your beloved ones that you have left behind.
So that means you may also have to tip those people off and tell them that listing you as an executor, which maybe many people might fear, and they say, if I tell this person I have this property and I'm leaving you, but if they now come to...
No. I think most times actually you have to agree, because someone cannot give you a role that you're not willing to take on, because this is full-time responsibility. And where this person has gone on, you're in that place to make sound decisions in the interest of the dependents that this person has left behind. So you have to agree and trust that these are the people and they should be willing to. And there has to be a witness. Okay, some people don't go before lawyers, but most times they can have those basics like we've shared. But I think also what's important to note that this will, like you rightly stated, that has to be often reviewed to ensure that it really reflects the true state of your affairs. You could die today and then you made this will like 5 years ago, and so the status quo of these properties has since changed.
You mentioned something like a car number plate. You might have, changed a car. Yeah, so that brings the question of how often is it advisable for one to review their will and update it?
I think as much as you kind of acquire new properties and your relationship with your people changes, or you could have your side chick and you say this side chick's children also have to be involved, because you could make it 5 years from now, and then in between those 5 years you've acquired more, or even a year. So for as often as your circumstances change in terms of acquiring more properties that you'd want to be managed the right way, and also your lifestyle or your social life status. Because you could, along those 5 years, also get another partner who could give birth, or you could adopt a child, not just even partners, because even the law recognizes children who are adopted rightfully within the Ugandan law as rightful beneficiaries of your estate. They could be included.
A curious question on that, because unlike maybe the Western world, which might be a little more developed, I find that we have what we call maybe informal adoption of children. I might have my brother's kids and they just bring them in, and there's nothing that shows that I'm now the legal guardian of those children. So in that case, what happens?
I think at the time of your death, if clearly these people have been under your care, they're referred to as your immediate dependents then. So if you pass on and you're making this will, you clearly recognize them as part of your dependents. And therefore the estate should be able to look after them, because before it was up to 21, but now 18, you know that still, even after their children going to universities, for example, and they still need this support, well, they also are entitled to your different properties. So there are certain percentages, again, in terms of the distribution of these properties. The only interesting thing now in the amendment is they want the immediate spouse, the person who, and a spouse is that person who you're legally married to when you pass on. And sometimes even in there are circumstances where people have actually divorced. Yes. But in the interest of property distribution and avoiding all these issues, you're still that kind of immediate spouse if the person did not remarry, for example, or bring in someone in the picture.
And I'm actually getting more interested. Actually, off the back of this conversation, you've put me in serious trouble. Now I have to go and review this particular law amendment very much.
That's exactly why we're having this conversation.
I'd like to see this again, the faith input, the religious input into this. Because I see a lot of the things that Dorothy has mentioned are things that are already laid out, like from an Islamic perspective. For example, you must have 3 witnesses who, testify. The way you write the will, because actually that's why it starts with a date. So you put a date there. You put Bismillahir Rahmanir Rahim, in the name of God, the most gracious, the most merciful.
I think in the Ugandan context, you put the Republic of Uganda,
You can add this one, but we start with that one.
That is if it's formally drafted by a lawyer. But there are also instances where
you are in the same mind. Done by yourself,
So you are in the same mind, so you're sort of saying, I'm writing this not under duress. I'm really in most comfortable state of mind.
State of mind is critical.
And I'm writing this and not under duress. I have this number of children, this number of wives. Because once that is laid out, then it's assets, it's liabilities, it's people you owe, it's people that owe you.
You have to state your
actually,
background.
that starts establishing
like who you are.
Oh, so that's also a point to note. Make sure that you know where you come from.
Yes, that places
lineage.
But does it make it invalid if you don't include that detail?
I think it just comes obviously. What is important is who you are defining, me so and so of this age, owning this kind of property, born to so and so. Because I think trusting is critical.
Yes.
Yes, in managing.
And so having that in time, and then the people who will look after your estate, the executioners, the executors, who will be able to execute your, your affairs once you're gone. And that all is stated out. You see to these people, and there are 3 different copies, because all these witnesses keep a copy of the will.
Yeah.
That's the one other thing, that they will have a copy.
Yes.
So when someone passes on, all these 3 people who have been mentioned come, and their copies must resonate.
And they align.
So in case there is any differences, then that's where the questions come in. But making sure that happens, because now some people fear that if you make someone a person who is going to be an executor in your estate, they might actually work very quickly to execute you.
Exactly.
To make sure you can live so quickly to allow
And you see now, the interesting proposed amendments also caters for instances where fraud could arise. Initially, probably like your signature could appear on the last page.
Yeah.
Your witness who has seen you, draft an attest. But now the law says every page should have probably like your initials, because we've seen instances where someone can actually plug out one part of that will and does whatever they want with it, and then they put it as part of the the wishes of the person who has now passed on and who cannot defend. So now that the proposed amendment is saying every page should have your initials, and I think probably that should even apply to the witnesses.
He mentioned something earlier about maybe using voice or technology. I've seen wills where someone sits and they record themselves, and in that case maybe the signatures may not apply, but where maybe if it's visual you can see this is the face of the person. Where it's an audio will, what happens in that case? What provisions are there to authenticate?
I think it also goes back to the circumstances again. Like, for example, if you made your dying wishes, we call them in law the dying wishes in law to verify and say, the circumstances really will determine how far to stretch and take the intentions clearly. But of course, you'll be treated as a person who has passed on intestate, without doubt.
A will.
Yes, you'll be treated like somebody who has died without a will. However, this voice note and all can just come in to guide those who, who are going to be taking on the succession issues, on how to best handle, picking from your thought process then while you are recording this. And this also depends on the circumstances. If you're on a hospital deathbed, for example, depending on what kind of disease you are, clearly there's a bit of duress or pressure. The circumstances really help people interpret where the person was coming from. But also, most importantly, I think for us where we're heading to is the principles of equity and justice are central and key. And even when you look at the proposed amendments, I may not have all the sections offhand, they're really breathing life into the principles of equality before the law, non-discrimination based on sex, age.
So there's a possibility that we might end up actually getting the audios and videos admitted as part of technological advancement. Because now you can file cases online. You don't have to go to the court. That's what has been.
COVID really has changed a lot of dynamics and how we
could it be that maybe it's a conversation we can start having as well, because it might lessen the duress, especially for people in the villages. They've managed to get the smartphones, but getting to the point of writing officially.
Or because it's true, there are people who actually know what they want, but they cannot write. They do not know how to write.
Interestingly, people in villages are very organized too. Like, I'm not trying to give them a lot of, but you know how they track their records. It's like even in Uganda here, you can trace up to your great-grandfather. They had their own way of documenting this. I think when we're talking about technology now, it's mainly in the elites, like not just, okay, maybe I want to say that the circumstances amid the pandemic have shown us that there are so many issues, options that we can explore, just like even admitting evidence in courts now. Audios and all can be admissible as long as they're in line with the communications, media, whatever, the guidelines or regulations. So I think it's an option to explore. And for me, why I would welcome it is anything to ensure that justice is administered to the ordinary person, to the families of the people who have passed on. And I think when we're now talking about the law of succession, you're looking at a woman and a man in that lens. The law of inheritance, you're looking at, because most times when you talk about succession and inheritance, the minds go to men as the ones who own property.
Who died first as well.
And who died first, but also own property. know, there's always this bias at the back of people's minds that actually married women or women in general do not own property.
Or cannot handle property.
Or cannot handle.
And that's why we're having this conversation.
Property, which is not right. I think most times what we can do as us is educate women on the power of documentation too.
Yeah.
Because we've had instances where women divorce, for example, and they go away without anything.
Yeah?
Yet they've made contributions, they've even paid for the tiling, for the land, but they've done it in trust based on love. You know, they send money through the guy's account. When the man is purchasing property, you know, she's a witness, not a co-owner to this property. And being a witness is so different from being a co-owner. And then there's this assumption of, oh, when you're legitimately married, it is obvious that the marital home will pass on to
you, which we have seen from experience that it's not
the
the
wife.
case.
But it also takes a lot of strain and legal battles and family, you know, issues to really, for you to assert your rights and say, you know, yes, this is obvious. So I think the power of documentation is something that we really need to emphasize to our women and girls, that while you're contributing to this, make sure that should anything arise, you can easily claim for your rights or property rights.
Because you have written. And still going back to the will, you had mentioned listing properties. Is there a proper way of listing properties so that maybe it's not invalid when you leave your will? How are we supposed to list property as per the provisions of the law?
And for example, if you own the land, you have to list the block number, the plot number. If it's a lease, all these details you have to ensure. And again, that's why I'm saying documentation is critical, not just for women, but even the men or whoever owns property.
And has people, successors.
Exactly, because there has to be proof that actually this is your property. Most times they'll refer to the sale agreement. For example, if you've been swift enough and you keep your books in order, you go ahead to acquire a land title. There are instances where people have passed on and, you know, they say, I own this property, but I've sold part of this to this person. So put in as much detail as you can to reflect the true state of affairs. And the law is generous enough or considerate in terms of letting you be able to amend. We have the codicil. It's like an annex or a revised version or even addition. If I say now I've had this and this, you say referring to this, whatever I wrote then will not count. What I'm now adding on to this and this is what should be construed as the real state of affairs. So it should be as detailed as possible, even described so that people know if you've sold part of this land, there's a pending payment, they'll still have to follow up. So you should be able to really clearly state your affairs.
Everything that you own,
Yes, to the best of your ability and knowledge, and try to guide the people that will be managing this estate when you're long gone with principles of fairity. Yeah,
so on top of listing and putting that, you also have to attach those copies of the certificates. Is that what I'm hearing
you
saying?
It's important, yes. They should be easily traceable.
Indeed. And I know right now Kassim's mind is thinking of, he says he's going back to amend.
Yes, to read the amendment itself.
The succession.
To amend my knowledge as well on that.
Important.
Yes, absolutely. No, I think it's quite interesting. There are lots of things that we seem to take for granted until a situation arises, then you suddenly realize, you know, what's in it. And many people find themselves in difficult situations simply because they've underestimated the power, say, of a will, but also the power of witnesses. Because really and that's why actually there's even a definition of these particular witnesses. It can't be anyone. It has to be people of integrity, people who are respected, people who are known.
Of sound mind.
Why? Because they will come in and their word must carry weight. If you choose on people to be your witnesses and they are really shaky in terms of their character, in terms of their, you know, their acceptability within society, that can actually raise grounds enough for someone to try to contest this. It has to be people of integrity, and that integrity means that, you know, they are not questionable in terms of character. They would be people who would be able to stand out for you.
The new amendment talks about consent of the executors. How is that, for example, if you're listed somewhere, how does that consent have to be, you know, well listed out so that we know that if Dorothy was listed, she actually consented to this?
Okay, I think it also goes in terms of how you draft this, the writings, because before lawyers, I think there's that provision where you say, I dash and dash to agree or accept to take on the role of an executor and all that stuff. But the mere fact that you've actually witnessed, I think for me that is the principle here. The moment you attest your signature, that is consent.
Yeah.
As long as the other principles of sane mind, you have a relationship, you apply, it's considered consent. Because there's no way you can put yourself on a document that you've not reviewed the content, you do not know the responsibilities that it comes with, and all that stuff. So that's why it's critical, the issue of making sure that the
signatures, the will is signed, and there are witnesses to it. Yes. And there's also a clause on intermeddling, which makes it an offense. Help us understand, what is that intermeddling that the amendment talks about?
So intermeddling, for example, if I am the executor of a building, and then I wake up one day and say the best decision for this building is to go away. I get buyers for this building, and I do not consult the beneficiaries of this property.
Which we see happening a lot.
Oh, it does happen.
Exactly. Then that is intermeddling. If you start distributing properties or favoring one family over the other, or certain dependents over the other, yet clearly there's a guidance on fairity in the law or even in the spirit of the person's will. I think intermeddling is basically running away from the spirit of the will that causes harm.
But if I'm listed as an executor, don't I have the right? Because I believe I've been entrusted with doing what I think is in the best interest. If maybe I want to list the company on the security exchange, can't I just do that? How do I do it?
There has to be consent, though.
Best interest. I think the underlying principle here is in the best interest. For as long as you act in the best interest of this estate, you're not bringing in issues of debts. You're not, selling out properties to your benefit without consulting. And by the way, even those that you manage for have the right before the law to ask for you to be struck off. For as long as there's belief, there's proof to actually show that you're intermeddling or you're not handling this property.
Even when they are below the age of 18?
The guardians can come in.
In the instance where maybe, because we see this happening, where, like I mentioned, especially when children are so young, for example, and maybe you're the sole person that they have to do this, and that's happening, where do these kids run to?
Of course the Children's Act is there, but also we have the Succession Act again. And most times the children cannot really do so much.
Yeah, if they see something is going against their will, but constitutionally they are below 18 and they wish to do something.
I think they can sue through a next of friend. There's that issue where they say that a person of age who is acting in your best interest can come in to institute a legal matter on your behalf, or even your guardian in that instance can come in, and even your spouse. You see, most times maybe a spouse may not even be part of the executors, but she is holding this, like she has the best interests of this estate.
Children, so
or
that
means, husband.
So that means we should empower our children out there. If you're writing your will, you let them know what you're writing, you let them know who the executors are, and you let them know maybe who to run to in case.
Unfortunately, our African setup or our context is also tricky. And you see, we've had instances where actually what we want to call children, and children could be above 18 as long as you have a father or mother, or yes, you're still a child in their face. It doesn't matter how old you are. But we've had instances where people have gone ahead to, and again, the people that you choose to run your estate count, they should be able to keep these secrets.
That's why I was going to come in.
They should be able to keep these secrets, because I am telling you, cases of gender-based violence, spousal, crimes of passion, people murdered, parents, children murdering their own parents over third day, again, that day for me to be able to inherit this property. So I don't think it's wise for you to sit down and say, let them work for their own.
And they'll just find the surprise later.
No, they will know that Papa has these properties and all. Definitely there is a plan, or Mama has this property. There should be a plan, to manage this property. But to avoid a lot of tensions, some will say this one was more favored and all. To avoid a lot of tensions or violence within homesteads and all, the conversation should really be between you and your executors, and you're just hoping that they should be able to be adult enough and responsible enough to ensure that peace and harmony within these homesteads are maintained when you're long gone.
And how much information actually you sort of share, especially with the children. You can share general knowledge. We own this building, we own this, but how that will be run now goes to the executors, your friends, the people that are going to, sort of see through your entire process.
Some people do not want to. They'll just say maybe we own this and that, but they don't declare everything. And maybe when time comes, maybe someone knows that the will is somewhere, and they run very quickly and they take away those things because the family
that's why you have
more
the three people, the three witnesses.
Of the will.
You have 3 witnesses, and then even a 4th copy with your lawyer. Some people would keep them in the bank. You keep it with your bank manager. These all come in to protect, the estate, to ensure that you are there. And that's why actually the people who are witnesses even have to take an oath, at least from an Islamic perspective, before they come in, to provide the copy that they have. They take an oath. They take an oath to say, I swear in the name of God that whatever I have, whatever I possess, whatever I'm going to submit is true to the best of my knowledge, as far as the deceased left it. So once that is submitted, all the 3 people, in case there is doubt, again, I'm talking about the Islamic perspective. In case someone is doubted, that's why we're talking about people of character, people of integrity. The moment that person is questionable, they found him peeing on the roads, by the roadside, that takes away your integrity.
That's enough to take away your integrity?
Absolutely, because now, if you are busting, then the circumstances, again, it is circumstantial. But what I mean is something that is not looked upon or frowned upon by the society, by the community. Then it starts raising the questions about the person. But you get these 3 people of integrity, they take an oath, and then given what has gone in there, in case you actually change anything, again, the copies now have to revert, and you have to change all of this so that it is reflected. For the spouses, again, it will be on the information. And that's why actually the issue of inheritance is big. Women contribute immensely, like in construction of houses or whatever. And then, the person dies, and then, that is not reflected at all. And then the property has to be distributed out, which
according
comes in with a
to
lot
how
of
people
unfairness.
think.
I think the law really comes in to help, and I hope it can be implemented well, because quite often you find, again, it goes into the courts of law, and then some money starts passing, exchanging hands, and things are done in a different way. But the will really is the secret behind all of this. Have the right will. Yes, have a right will. It is going to provide a yardstick. It's going to be a channel upon which everything else can be run.
Have a will, have it right. If you're in a relationship, especially women, make sure that you have those difficult conversations, and don't just give yourself away and you hope for goodwill. That's what I'm hearing from you. And from an Islamic perspective,
if you have children that were born out of wedlock, the only
wedlock
protection
would be out of the 4. Who are maybe not part of the 4?
Yeah, who are not part of the 4, because the 4 now would be what laws would be official. If there are any that are outside that, or even you might even have one wife and then you have children probably from a previous relationship but which was not married.
They have the right to belong to our family and property.
So because they have that, at least, and that's why I was saying I wanted so much to hear how much faith consultation went into this.
Yes.
From an Islamic perspective, it would be that if you're born outside wedlock, your father has the right to give you a property while he's still alive. That one in the will now.
There are also instances actually in the will.
Yes.
And that's why we're talking about the details of if I've given so and so this kind of property and all, you state it.
Yes.
Even when you're living, it's okay for you to actually distribute part of your belongings while you're still alive.
Islam allows you to distribute 1/3 of your property. Yes. So 2/3 is what is now goes to the official channels. But at least 1/3 you can give her while you're still alive. Okay. So in that instance, the children that are born out of wedlock, that is the opportunity. Or people that you have adopted, because Islam does not acknowledge adoption. It allows fostering, but does not accept adoption. Because adoption in the secular sense.
The issue of adoption, and also when we're talking about how much culture influences or religion, the Constitution is the supreme law of the country. Whether you have other statutes or laws, the Succession Act, the Land Act, the Children's Act, all these have to breathe they should be synced with the spirit of the Constitution principles. So if Islam does not acknowledge adoption, yet the law
acknowledges adoption,
yes, it supersedes, it overrides. You get it? Whether the religion accepts it or not, as long as it is recognized under the law, and it's consistent with the provisional constitutions of justice and equity under the Constitution of the Republic of Uganda, then
it supersedes.
That's
where my worry was, Martha, because I was saying how much consultation has gone
gone
so
into
at least
that.
People have had an input. Because with the marriage bill, marriage and divorce bill, Oh, you know how heated that was, and religion actually played a very key role.
Yes.
It has gone back and forth simply because there were those pertinent issues that come from a religious perspective with a lot of sense in them, but then they had sort of either been ignored or not validated. So it would be good just to see how far this one can go in, at least to sort of address those issues.
Yeah, so to take it back now to the national perspective, because we've gone to, the family, which I believe is very important, because I think a family is the first unit of the country. At the start of the show, you mentioned how we've made great strides as Uganda. You also mentioned how compared to other countries in the region, Uganda is far ahead. For people, or maybe for those of us who may not have had the chance to compare or who've not had the chance to travel, what things stand out, or if you can help us maybe highlight a few of the milestones of Uganda where we can say, okay, it's good we've made this progress and this is where we are at now, and maybe this is what we can improve upon going forward.
I think the being intentional as a nation, even the government, because earlier on we said that our succession decree states from 1906, and the British looked at a unit as one man, one wife, children born in that context. But what Uganda has been alive to is our society is unique in nature, and it's not static, and it's tried to redefine what kind of families and unions that we as nationals go into. Because when you're talking about succession and inheritance, you have to trace back to what you define as a family and in what context. So when I was talking about the Kalema Commission, it also went on to say, you have this Succession Act crafted in the ages of the colonialists, that is not considering the rights of women, for example, who have been customarily married off, who have, gotten children and are not recognized as a wife because they've not gone to church. What do we do? And that commission comes up with recommendations based on research, based on interviews, based on findings from our societies.
And consultations.
Yes, to say that we need to actually pass a marriage and a customary act, let me put it that way, like guiding us and defining for us what constitutes a valid customary marriage. And they tell you that this is a marriage that is recognized for as long as it fulfills the culture or practices of that tribe that you're marrying into. Okay? Now, you've even seen the trend. People go to Kwanjula, then they go to church. But I want to assure you, whether you're customarily married or you've gone to church, all those are recognized marriages. You're actually having double, I think, because of the comfort that, the church is the one that is really held in high regard. And I think it's in
the colonial past as well,
so
how we were set up. We
now where we are right now,
wedding,
yes, that commission is successful. It now starts acknowledging customary marriages. And what does that do? It's actually protecting women. Where they've gotten like one, multiple partners and all, and they're having children for this person to be acknowledged and entitled to own this property. So that is a positive thing. And through the journey again, we've seen the Succession Act go through different reviews, 1972, 2005, the constitutional case that was challenging its unconstitutional provisions in terms of being discriminatory based on sex, in terms of distribution of property inheritance and all. So what is beautiful about this proposed amendment is, like I keep saying, is the language. It breathes in a lot of life in terms of being gender sensitive, giving equal rights to the girl child to own property, because inheritance and succession, who is your immediate? And now they say that whether a woman has gone before the husband or the husband before the wife, they will treat those rights as equal rights. And then it's also proposing to say that the percentage should be increased. I think it was 10% going. Now either 20 or
it's 20,
I'm not sure.
It's 20%.
Yes, 20% now going into the immediate spouse, because they know that at the end the baggage lies on you, and it's only fair and just that this percentage goes in. The new law also now redefines what illegitimate. It doesn't talk about the language that really creates more discrimination in families and has been an issue of gender-based violence and all those contestations. It just says a child.
Okay.
So the issue is illegitimate or not is not
you're
now.
Still a child. We are almost coming to the end of our show, and I think if to sum up the action points that have been made here for anyone that is listening to us is that the media should be more intentional in how we report, educate ourselves, but also the civil society and agencies should include the media a lot. If you're a woman and you're entering a relationship or you're with someone, make sure that you work on it to be recognized by the law, and then write your will and update it very often, because that's how you'll be helped when that time, that eventuality happens. Maybe, I do not know, in just a minute or two, one thing that you wish our viewers can take away as a parting shot, either from Dorothy as a person or from CEHURD that you're representing, just in 30 seconds, actually, from both of you.
Thank you so much. I'll speak on behalf of CEHURD, Center for Health, Human Rights and Development, that has given us this platform through you, that it is very, very important for us to support the cause of civil society organizations, especially when it's to do with proposed amendments in the laws. Let us as society see the good in these laws and mount pressure on our decision makers to actually act on the interests of the constituencies they serve. As a nation, we've made strides, and I would like to thank all the women movements, civil society organizations that have contributed to this journey up to where the Succession Act is now looking in the proposed amendments. We thank the Parliament, the 11th Parliament. I know it's been a journey for actually passing this bill. Currently, the bill is before the President for assent. My humble appeal is to the President of Uganda. As women celebrate the International Day on 8th, let us breathe life. Let us pass this law and let's have it implemented. It will resolve a lot of issues. We've seen cases of domestic violence, gender-based violence that attack to property. So this law coming to life would really resolve a lot of these injustices and promote equality.
My producer tells me that we have run out of time, but I would like to thank you two so much for sharing your experience and observations and expertise with us. And thank you for staying with us until the end of the show. You're watching CTV Month of the Woman, where we are talking about issues that affect women, young girls, and women in our community and children. And we'll be bringing you more guests to share this. So stay with us here on CTV and don't blink.